back to this. Now, just briefly, I want to cover this because I think it's important that I do. On your screen as we speak, you will see legislation.gov.uk, right? You will see the Criminal Justice Act 1988, Section 134, torture. This was brought into domestic law after the British ratification of the United Nations Convention Against Torture. This gives you another route into, believe it or not, another jurisdiction, which is the United States of America, to hear these cases of torture against the police and the authorities, including judges, etc., council officials, police, chief constables, judges, prosecutors, etc. And in this document, it tells you torture, section 134, a public official or person acting in an official capacity, whatever his nationality, commits the offence of torture if, in the United Kingdom or elsewhere, he intentionally inflicts severe pain or suffering on another in the performance of his purported performance of his official duties. Right now, the crucial part of this, apart from that laying out the offence, you must know that torture does not mean pulling out your fingernails. There is a whole definition, legal definition of torture. Rape, psychological harm, pain, suffering, there's lots of things that covers torture. It's not pulling out your fingernails to get information, right? Care workers, etc. But section 2, a person not falling within subsection 1 above commits the offence of torture, whatever his nationality, if, in the United Kingdom or elsewhere, he intentionally inflicts severe pain or suffering on another at the instigation or with the consent or acquiescence of a public official or of a person acting in an official capacity. So if the Muslim Pakistanis are committing these offences and the local authorities acquiesce, so they just let it carry on, or in some cases they've consented to it. The key word here is or, right? Or, not and, or, of person acting in official capacity, and the official or the other person is performing or purporting to perform his official duties when he instigates the commission of the offence or consents or acquiesces in it. Now, there is further section 3, all of these prove guilt, and it's an easier offence to prove, right? It is immaterial whether the pain or suffering is physical or mental, and whether it is caused by an act or an omission, right? Omission means you know it's Pakistani Muslims, you know who these people are, and you have omitted to put it in your reports. You have omitted, in other words, you haven't put it in there. So omission is key because it means you're not being truthful, right? The truth is you either tell the truth or you omit to tell the truth, right? And that is an act of fraud on the people. It shall be a defence for a person charged with an offence under this section in respect of any conduct of his to prove that he had lawful authority, justification or excuse for that conduct. Well, there is in law no justification for that conduct. So then it goes into detail. This is basically this act was and this section was brought in 1988 on the tricentenary of the English Bill of Rights. Right. I'm going to jump to section 6 because some of this doesn't relate to what's going on. But section 6: a person who commits the offence of torture shall be liable on conviction, on indictment, to imprisonment for life. That means it is mandatory, right? Now, the next section of this is the part that can propel you to the United States of America. And this is section 135. This was changed unlawfully, by the way, but we won't get into that. Requirement of Attorney General's consent for prosecution. So if you want to privately prosecute for torture, state officials, you have to ask a state official for permission to do so. And we've done all this with Charlie Stables. Proceedings for an offence under Section 134 above shall not be begun, A, in England and Wales, except by or with the consent of the Attorney General, or B, in Northern Ireland, except or with the consent of the Advocate General or for Northern Ireland. Why is that important? Because we've already been through this process. We've appealed it. We've gone all through it. We went to the High Court, etc., and they would not let us start a case of torture for Charlie Staples, right? Why this is so important? Because you can bring this case in the United States of America, right? Under the United Nations Convention Against Torture, because it was ratified by the United States of America to allow for this case to be transferred, just in case people in the United Kingdom, the British, wouldn't allow this type of case to proceed against the actual people. So what I'm going to do now is explain something else. In the early 1930s, the British abolished an ancient law and custom of the English. It was called grand juries, right? So grand juries was what they've still got in America, which is a way of us bringing people in, and putting them in front of a grand jury. This is about the probable cause, right? So the first stage of this with a grand jury, the grand jury either can give you a presentment or a bill of indictment. And a bill of indictment from a grand jury is the highest form. You can go anywhere in the world if that person's, left the country, pick them up and bring them straight back. And then they face trial, because the grand jury isn't the trial itself. It is presenting evidence for the jury to decide whether there is or there is suspected and there is evidence of a crime being committed, right? A serious crime being committed by state officials, by anyone, basically. And again, that was removed illegally, unlawfully from our rights and customs as English men and women in England by the British. And it was one of the things that was in place to stop this level of corruption. Right, so if Restore Britain's serious, they would bring back grand juries. No,
The English Constitution is the solution, always has been and always will be.